The second makes this fellows even more bizarre. There is no counterpart to curiouser and curiouser. It can't be bizarre and bizarre. Well, there is a direct finding in not one but many paras of the EC order that this is a split. I'm not asking a lot, Justice Shah is right. We are not on the appeal on that. That's not the point I'm arguing. I'm on the context, fellows. People are here going around merely on the assumption of a split. Then the Lordship might as well wind up the 10th schedule, the constitutional amendment, the deletion. What's the point of it? I'll give the paras. There's more than 4 paras or 3 paras in the EC. We'll just give the paras. Yes. Now, Millets, therefore, your lordships and those cases don't have to be given to your lordships of elementary forms of interpretation that if I delete something, your lordship gives effect to the deletion. I'll supply them, Millets. It's not necessary to do it. The second answer or the second Millets response in the larger context of that query. So this is the first response. The second is, Millets, your lordships decides cases. Not that your lordship decides the narrowest of narrow issue, your lordship decides the whole context. But your lordship doesn't decide beyond the context of a case. Your lordship is very careful, otherwise one of the things of biter and all that come in. And your lordship doesn't have time to spend on hypothetical questions. But let us see the context. The context of this case can be divided into broadly 2 or 3 or 4 categories. And that context makes it clear that your lordships need not be bothered about the governor coming into the picture at all. The first phase of this context is the expedient of giving a disabling notice. I call it a disabling notice before I intend to defect. Now, that will be awaiting your lordship's decision on Nabab. So, phase 1 or part 1 of this context is disabling notice. Your lordship must decide in Nabab. That's the whole argument we made for 2 days. But clearly the context is that step 1. And if that is wrong, then a lot of things fall down. And that is wrong in case a lordship doesn't agree with the literal text of Nabab. The second part is that we are also forgetting repeatedly the object of the 10th schedule. Well, as more than any other jurisprudence in this part, subject of constitutional law, are cases again and again talking of 2 things. The evil prior to 84, the object of plugging that evil, the mischief rule, and what your lordship is doing by the 10th schedule. The third